can I invite all our panelists, please, to switch their cameras on? I'm going to deal with some of the questions and points of debate raised by our audience. Thank you very much for the questions on Twitter and via the email system. There's been so many, I can't take them all, but I will deal with some. Can I start with a question I think Thomas McGarvey is the best to answer, please? Thomas, Shaun Harrison from the Press Association, PA Media, says this: if you had to identify the single biggest issue with Diplock trials in dealing with the backlog of Crown Court cases, what in your view is that single biggest issue, please? Thomas, and your microphone on, please.
Thank you, Colin. I think there are two issues in reality. It depends who you're talking to. If I were the defendant, for example, and it's difficult to put myself in those shoes, obviously, but if I were, I would say consent is the single biggest issue. It has to be at the very top of the hierarchy of issues that surround Diplock-style trials. And so if you have the consent of a defendant, then perhaps that begins the conversation, and I only say begins the conversation, of whether it's appropriate to have a trial without jury. In balance, you have to have a position whereby if a defendant says, actually, no, I don't consent to a trial without jury, that defendant won't be unfairly disadvantaged, for example, spending a sustained period in custody on remand or anything of that nature. And perhaps in the current climate, that's a difficult thing to facilitate. There are ways around it. Of course, there are ways around it. It really comes down to, as it so often does with the criminal justice system, investment. If the government wanted to, they could, of course, look at options such as Nightingale-style courts that I think have two benefits. The first is it would provide a safe place for jury trials to take place in the way they always have taken place. And so people could enter and leave safely with appropriate social distancing. The added benefit of that would be it would empty the current court estate. We wouldn't be using our Crown courts while we're using Nightingale-style courts. Now, why would that be beneficial? Well, because they're decrepit. They need investment. They need renovation. Dare I say it, they need to be increased in size. We need new courts. And so in the circumstances, if we had consent, then I perhaps would advocate that. I leave this with one point, Colin, if I may, quite embarrassingly so. Celine Dion wrote a song once called Think Twice. I know because my mother used to play it every day when I went to primary school. And there's a line in that song that says, think twice before you close that door. Well, may I turn that on its head and say, think twice before you open that door? Because to misuse a judge-only trial in circumstances such as a pandemic would be perhaps to cover up the true problem, the true issue of why we've got a backlog. It's not because of the pandemic. That has just made the backlog worse. And so if we open that door, will it ever close with the government that we have now? I fear the answer to that question. Thank you, Colin.
Thank you. And perhaps, Thomas, there's another poll question there, which was asked, in fact, by Lauren, that should there be a power full stop without a test that consent's enough? Perhaps another one for our polls.
Yeah, I seen that question come in, and actually that's from Laura Payton, the Chief Inspector of Prosecution in Scotland, Colin, who sent the question in by email. I think consent really has to be the issue. If we're going to have a conversation about trials with no juries, consent must be the starting point. Without consent, then it opens up a whole series of problems in respect of appeal. Did somebody have a fair trial? At that stage, will we even be part of the European Union? Will the European legislation apply? Who knows? And so consent, for my part, is perhaps the most important aspect of a trial without a jury.
Well, I think the EU is a whole different podcast. Perhaps we'll tackle that at some stage in the future. Can I come to Michelle, please? And I'm going to paraphrase a question, no discourtesy to the author. But an interesting point's been raised, Michelle. It's this. Kerim Fuad, Queen's Counsel, in his opening address, discussed the prejudices that people often suspect some judges have. They become hardened to it. Michelle, is there an advantage sometimes, though, that a judge wouldn't have the prejudices a jury do? For example, perhaps in some sex cases, or as Lewis mentioned very briefly, where they're being tasked with determining quite heinous crime, factually material. Is that an argument that you recognise could be used for a judge-only trial?
I don't recognise that at all. I've been at the bar 32 years, and I'm a passionate believer in the jury system and the jury's common sense. And my view is it's my job as a defence lawyer to be fully aware in any case of the potential for prejudice. Now, we know that judges give very full directions about stereotypes, but if I've not fully addressed it in my closing speech, and I don't treat the jury as a fool at all, then I've failed as an advocate.
Thank you, Michelle. And picking up on a theme there, if I can, And if I could turn to Liam, perhaps this question. Liam, a question's come in via the Twitter feed from Nicholas, which we're grateful. It's a similar theme here that with a jury of 12, you get a cross-section of society. They almost self-police themselves as any strong views expressed. Is there a risk, do you think, that if we drop to, say, 6, 7 or 8 jurors, something similar to what we saw in World War II, that we see perhaps racial profiling changing the jury and perhaps some racial bias and prejudices emerging as a theme? Any thoughts on that, Liam?
Yes, well, I'm reminded really of the great Celine Dion, who I believe said, "It's all coming back to me now," as I recall the Lammy report. So David Lammy carried out an extremely thorough report in 2017, looking at the treatment of minority ethnic groups in the criminal justice system, an independent review, and looked at over 400,000 cases. And pretty much across the board, in every category looked at, they discovered some sort of racial bias or discrimination, be that subconscious bias or actual sort of explicit bias. But the only place that they didn't actually observe any racial bias occurring was in the deliberations of the verdicts of the juries. So in the magistrates' court, minority women were 24% more likely to be convicted. Young, unarmed black men were far more likely to be shot by predominantly white police officers than white men. The prison population from minority backgrounds had a far more negative experience of prison and believed themselves to be targeted. But the only place that we didn't actually see any evidence of discrimination in society was from juries. So I'm not sure that cutting a jury in half, statistically speaking, would make it any more likely or any less likely that racial bias would be prevalent, especially if one assumes you would then have one person capable of dissenting in a majority direction. So I think the evidence actually supports that the population as a whole is far less racist than the individual, especially when they're on a jury.
Thank you, Liam. I'm going to turn to another topic, and I'm going to come to Amy and Shaun, if I may, just their comments on this question here. Not something necessarily that is going to happen, and can I stress, but there's been some proposals in the media that perhaps if you increase the powers of the magistrate court, say increase their sentencing options, that they could retain more cases, and that could be a way of dealing with a backlog. Just in a line or two, Amy, very experienced magistrates court and now in the Crown Court. Do you have any comments on that, please?
Very quickly, probably to go back to what Kerim Fuad of Queen's Counsel said in his opening, and before we resort to increasing powers, we must look at having all courts sit in and looking at reopening court centres, and this mustn't be seen, if it was to come in, as a quick fix to the backlog that was already accruing long before COVID, and then address also some of the recommendations highlighted in that report. Look at recruitment problems, increasing morale and training and qualifications for magistrates. These are stuff that all need to be considered before we look at increasing their powers.
I mean, Shaun, you've done a lot of work in the last week or so looking at what the future holds. Do you think it's a credible suggestion that the mags could come and save the day for us all?
Not credible. It is something which, in fact, rears its head at regular intervals. I look back sort of just to remind myself that it was something that was put forward quite strongly by a previous Lord Chancellor, Jack Straw, and then by Justice Minister, whose name, forgive me, I forget. But what I remember being quite worrying, looking back over the parliamentary discussions, was a suggestion that really we should not be spending quite so much money on cases where people are, for example, having jury trial in relation to shoplifting or thefts, when these are people who already have previous convictions, or where these are matters which are not particularly serious. So in reality, for expediency, we will end up inevitably being in a situation where the right to have a trial, a jury trial, will be substantially reduced, but also be done on a basis which really is in contradiction to the principles and interests of justice. So I think we ought to be extremely concerned about trying to pull back the borders to increase the amount of work being dealt by magistrates' courts. So It's
I'm
nothing
just
new.
going to deal. Sorry, Shaun, thank you. I'm just going to deal not with two questions, but just two comments that have come in from the floor. One from Leslie Manley, who's a barrister. She makes this observation in respect to diplock trials and judges alone, that sometimes you can have multi-handed cases, say 3 or 4 defendants. The jury tampering allegation is levelled at 1, but ultimately all the defendants get left with the diplock trial. And she raises that point for interesting debate as to the fairness of the same. Also, Stephen Gilchrist, who was in fact the solicitor, Lewis, in the case of the Ouija board, observes that perhaps the time has come for more research in both this jurisdiction and other jurisdictions on the jury trial system. It's an interesting point indeed. Can I come to Lewis actually with a question from the floor, if I may? James Belgium raises an interesting question arising from your speech, Lewis, where you dealt with you can lose a jury as an advocate. And the point being raised, really in the context of juries versus judges deciding guilt or innocence. If you can lose a jury, if you can make that difference, does the more forensic mind therefore not lend itself to trial by judge alone? You mentioned fraud cases not being utilised. Why is that, do you think?
Well, first of all, can I say, first of all, I'd like to say I have the most enormous respect for Celine Dion, because a couple of years ago, I don't know if any of you know, that she suffered a bout of amnesia, and when she recovered, she said, "It's all coming back to me now." But in answer to that, and you, Kerim, like that, in answer to that, yes, of course, it's important in the context of fairness, but judge-alone trials, I think, can have difficulties, and there's a perception of bias, because we all have had those cases in front of a jury. You think there's no chance in hell that you're going to get acquitted, and ultimately you do. And it comes back to the question, such as someone said earlier in their lecture, about whether in fact there are prejudices that you don't like to say from certain judges, and whilst you have a greater chance of appeal as of right from the diplock court, where the judges got it wrong, what you don't have with the jury trial is you don't know the basis upon which the jury has actually convicted. And therefore, a jury can convict your client, whereas the judge in a diplock court will have to give specific reasons as to why someone is guilty. And therefore, therein lies the difference.
Thank you, Lewis. I'm going to move, please, if I can, to Kerim Fuad, Queen's Counsel. A number of questions have come in really asking to draw together several themes. And what is really the biggest issue with trial by judge alone? And against that, Kerim, what is the most powerful argument you think there is for saying we need trial by jury and we need it to stay?
Well, let me deal with another issue before I come to that, because I've been receiving some questions as well, and I'm going to come on to the issue you've just raised. The issue I want to deal with now is going back to the pre-virus. People have been messaging me about, well, how many courtrooms have in fact sat idle. The statistics are absolutely terrifying. As I said, it's a very well kept nationwide secret. In December 2019, out of 729 available courtrooms, 350 were not sitting. And it was quite plain, I make it really on behalf of the judiciary more than anything else, that this was a Treasury-led political decision. It was nothing to do with the judiciary and the senior presiding judge at the time, Lady Justice McGarvey. It's all Treasury-led. Frightening statistics. Moving on to the question you ask, can I put it this way? Like all relationships, relationships are based on trust. And jury trials, in my view, are rather like a good relationship. They're based on trust, the trust between counsel, judges, court staff, defendants, solicitors, all to come together to achieve it. And we have to trust juries to listen to the judge. We have to trust juries to understand the judge. And if they don't understand, in my experience, they ask. They write a question. I don't understand that direction. We have to trust them to follow the judge's directions in law. We have to trust them to keep their emotion outside the courtroom door. And research has shown that most of the time they do follow the directions that the judge gives. And more, they ask questions. What does that mean? Could you give us another word to amplify that? And the way I'd put it is, how would you feel, I guess, if you're facing a murder with aggravating features that could lead to you having a starting point of 30-year minimum term before you're eligible for parole? And that decision was made by a judge. I mean, surely you'd want your peers to make that decision. And the best way I could describe it, I guess, is this. I'm head of chambers. I have responsibility over a lot of people. I can make my own decisions, thanks very much. And I hope to get them right. I hope most of the time I do it with the right intention. But you know what? I have a management committee. In fact, I'm looking at one or two of them now, because some of them are speakers on this webinar. And every month, that management committee of up to 14 people regulate me in many ways. I can form strong views, as some of you will know. But it doesn't mean I always get it right. And that management committee represent the whole of chambers. They represent the juniors, the pupils, really. Some of them junior barristers, some of them middle ranking, some the silks. They all have views and they represent those views and they're elected to represent those views. And I find that listening to differing or different views, or sometimes even views that confirm the decision I was thinking of, help me. And they help me get to the right decision. If I was sitting on my own in a management committee meeting, talking to myself and making my own decisions, I'm sure I'd get many more wrong. But because I have the benefit and wealth of different people, different age, different experiences, with thoughts that I may not even have thought of, then there's much more chance as a team that we get it right. And those 12 jurors are a team. And that's why, in a nutshell, I think it works.
I think Kerim unintentionally there left us with a final Celine Dion song. He didn't want to be all by himself. And thank you very much indeed for that swift and smooth ending, Kerim. Can I thank all the panelists today for joining us? Can I thank Loughlin for his organisation together with Tomas McGarvey? And can I more importantly thank all of you? We've had academics, lawyers, journalists, students, members of other chambers. It's a great audience to have debating these issues. Keep the debate going. Hashtag jury trials, hashtag church court chambers, and we look forward to welcoming you at our next webinar very soon. Thank you very much indeed for joining.